Okay, so we're back for another deep dive.
Always a pleasure.
Today, we're going to be looking at some pretty big changes
Mm-hmm.
in how our community is run.
Right.
Specifically,
Yeah.
some recent updates to the governing documents.
Yes.
The covenants, conditions, and restrictions, or
Yeah.
CCRs, as most people call them.
CCR?
And these aren't just like minor tweaks, right?
No, not at all. This is
We're talking kind of big shift.
significant.
Yeah.
Yeah, a really significant majority of homeowners approved these changes.
Yeah.
Like over 82%.
Yeah. That's a huge supermajority.
Yeah. You don't get that kind of consensus unless people are really feeling strongly that things need to change.
So that's what we want to understand today. What are these changes?
Yeah.
And more importantly, what do they mean for you
Exactly.
as a homeowner living here?
Mm-hmm.
And I also think it's worth pointing out that, the board has been
Yeah.
really good about, being proactive and making sure that
Transparency.
everyone understands their rights
Yes, absolutely.
in light of these updates.
Yes.
That's a good sign.
Very much so.
All right, so let's jump in.
Yeah, let's dive in.
One of the biggest things that I saw that's been updated is this whole section on limiting corporate rentals.
Yes.
So what's the thinking behind this, and what are the actual,
Right.
new rules?
So the idea really is to recognize that, owner-occupants, they just have a different stake in a community.
Right.
They're there for the long haul. They're invested in a way that's more than just financial.
Right.
And so that's really what they're trying to encourage here is, to recognize that and to bring that back into the community.
Right. So is this kind of a new thing, or is this just
Well, they've added
codifying?
They've added a whole new subsection,
Okay.
6.4 to the CCRs, and it's all about lease and rentals.
A whole section just on that.
Mhm.
Okay. So what are some of the things we need to know about?
Well, the first thing is there's a 1-year waiting period.
Okay.
Now, if you purchase a property in the community,
Yeah.
you have to own it for a full year
Okay.
before you're allowed to lease it.
So you can't just buy something
No.
and immediately rent it out.
Correct.
Okay.
You had to wait a year.
That makes sense.
The idea is to encourage people to buy with the intention of living there,
Right.
not just as an investment property.
Right. And I think a lot of people in the neighborhood were hoping for that.
Absolutely.
Yeah. Okay. So let's say you do decide to rent it out.
Right.
After that year.
Right.
What are the requirements?
So there's a bunch of new requirements.
Okay.
First of all, any lease agreement you enter into, you have to provide a copy to the board.
Okay.
You can redact personal information like social security numbers and, that kind of thing. But the basic terms of the lease need to be there. The lease also has to be for a minimum of 12 months.
Right.
And it has to state very clearly that it's subject to all the HOA's governing documents.
Right. So even if the renter doesn't know.
Right, as if they were an owner.
Yeah, they're basically bound by the same rules.
Exactly. And this is a big one. The lease has to give the board the authority to take direct action against a tenant for violating the governing documents.
So they don't have to go through the owner.
Right. They don't have to go through the owner first.
That's a pretty big change.
It is.
Interesting. Okay, so
it's designed to just make sure that the rules are enforced consistently.
Right. And I think, that's been a complaint of a lot of people.
Absolutely.
Yeah. Okay. So what happens then if a homeowner, has a legitimate reason to rent?
Right.
Before that year is up.
Right. So they have something called a hardship exception.
Okay.
The board can waive the waiting period.
Okay.
If you can show that it would cause undue hardship to enforce it.
Okay.
There are some examples in there that give you an idea of the kinds of situations they're talking about.
Sure.
Death of an owner, necessary relocation for caregiving, job transfer, retirement, divorce, marriage, that kind of thing.
So major life events.
Yeah.
But not just like, I want to go on vacation for a year.
Right, exactly.
Okay.
So it's really up to the board.
Right.
They look at it on a case-by-case basis.
Okay.
And decide.
Okay. One thing I also wanted to clarify is, even if you do rent out your property,
right,
you're still responsible.
You are still 100% responsible
for your tenants.
As the owner.
For anything they do.
And for them complying with all the rules.
And all the HOA rules.
Yeah. So just because you have a renter doesn't mean...
Absolutely.
Yes, you can just wash your hands of it.
No, you're still on the hook.
You're still on the hook. Yeah. Okay. So what happens if someone tries to just skirt these new rules?
What are the consequences?
There are consequences. First of all, any lease that doesn't comply with the new rules is voidable by the board.
Okay.
They can just say, sorry, this lease is no good.
Okay.
And on top of that, they can fine you up to $100 a day.
Wow.
For each day the violation continues.
So that can add up really quick.
Oh, yeah.
Okay. And these fines, by the way, just to clarify,
yes,
plus any costs associated with collecting them,
including legal fees,
can become a lien against your property.
Yes, they can.
And are your personal responsibility.
As the owner.
At the time that those charges were incurred.
Correct.
Wow. Okay. So they're not messing around.
No.
They're serious about this.
They are serious.
Okay. What about foreclosures?
Right.
How do these rules apply then?
So the rules exempt institutional mortgage lenders who take possession of a property through foreclosure. So if the bank takes it back, they're not subject to these rental restrictions, but as soon as they sell it to a new buyer, then all the rules apply, including the 1-year waiting period.
Right, so the clock kind of resets
exactly
with the new owner.
Exactly.
Okay. And then how does the HOA determine if a property is being rented or not?
So the CCRs state that if a property is not occupied by the owner, there's a presumption that it's being leased. And therefore subject to these regulations. So the burden of proof is on the owner.
So you have to prove...
You have to prove to the board.
That you're not renting it.
Right.
If you're not the one living there.
Exactly.
And they also clarified what constitutes a lease.
Right. Any occupancy by someone other than the owner is considered a lease or rental. Unless the owner provides the board with a written purchase contract where the occupant is legally obligated to buy the property by a certain date.
Like a rent-to-own situation?
Even a rent-to-own.
Wouldn't count.
Unless there's that.
Unless there's a firm contract.
Legally binding purchase agreement.
So they thought of everything.
It seems that way.
Yeah. All right. One last question about the rentals.
Yes.
What about existing rental agreements that were already in place?
So there's a grandfather clause for existing rentals. If you had an active lease in place when these amendments were recorded, that lease is exempt from the 1-year waiting period. As long as you provide a copy of the lease to the board within 60 days.
Of the recording date.
Of the recording date.
So it's not like everything changes overnight.
Correct.
But it is important to note that those leases are still subject to all the other...
They are, to all the other provisions we've talked about.
So it's not like you're totally off the hook.
Right.
You still have to comply with the other stuff.
With everything else, yes.
Yeah, and if you sell that grandfathered property...
Correct.
The new owner...
Is not grandfathered.
Is not grandfather.
They have to go through the waiting period.
So that's really important to clarify.
Yes, it is.
So that's the whole rental thing. The second big update I want to talk about is this thing about the Planned Community Act.
Yes.
What does that mean for our community?
Well, it's a big step towards aligning the HOA with current state law. The community has adopted Chapter 47F of the North Carolina General Statutes, which is known as the Planned Community Act, as amended, and any future amendments to it.
So any changes to the state law will automatically apply?
Right. And the specific reference is NCGS Section 47F1-102.
For those who want to look it up.
For anyone who wants to read the actual statute.
So what does this actually do for homeowners here?
So basically the Planned Community Act, think of it as like a set of rules and guidelines created by the state to make sure HOAs are operating fairly and consistently. It covers a lot of stuff, how meetings should be run, how financial records are managed, the rights and responsibilities of both homeowners and the HOA. So by adopting this, the community is agreeing to operate within these state standards, which can be a good thing. It provides more clarity, maybe even some protection for homeowners.
Because it's not just the HOA making up their own rules.
Exactly.
They have to follow.
You have to follow the state law. That
makes sense. The third big change that I saw. And I think this is a really big one.
It is.
Is that they've made it easier.
Much easier.
To amend the declaration. So this seems like it could have a pretty big impact on
a huge
the future of the community.
Well, in the future, So tell me, what did you learn about?
So previously, to amend the declaration, You needed a 75% vote.
75% of all homeowners.
Of all homeowners.
Had to vote to approve it.
Which is a lot.
It's a very high bar.
Yeah.
The new requirement is a vote where the number of votes in favor exceeds 50% of the total number of resident owners.
So not renters.
Not renters.
Just homeowners who live here.
Correct.
So that's a pretty big difference.
It is a big difference.
Yeah. Can you give us an idea of how much easier that might make it to pass amendments?
So we know there are 154 homes in the community. And approximately 40 of those are rentals.
Okay.
So that leaves around 114 owner-occupied homes.
Okay.
Under the old 75% rule, you would have needed 116 votes to pass an amendment.
Right, because it was of all the properties.
Of all the properties.
Okay.
Now, with the new rule requiring a majority of owner-occupied homes, you need a majority of 114, which is about 57 votes.
So you've gone from 116 down to 57.
Wow.
Big difference.
That's a big difference.
Yeah.
Yeah. Okay. Are there any conditions or limitations on this new amendment process?
Yes, there are a few.
Okay.
First, as long as the original developer still owns any property in the development.
Okay.
Any amendments still require their written consent.
Okay.
So they still have some control.
They still have some say.
Yes.
Okay.
Second, the developer can still amend the declaration unilaterally.
So without homeowner approval?
Without homeowner approval.
Okay.
If it's necessary for compliance.
Good.
With FHA, VA, Fannie Mae, all those agencies.
So like if there's some federal rule or something.
Exactly.
They can still make the change.
You can still make the change.
Okay.
And then finally, any amendment, once it's approved by the homeowners, it's not actually official.
Okay.
Until it's recorded.
Yeah. With Mecklenburg County.
So there's still a process you have to go through.
Right. You can't just vote and then it's done.
Yeah, you got to file the paperwork.
Exactly.
Right. So that's a lot of information.
It is a lot.
We've covered the new rules on corporate rentals, the adoption of the Planned Community Act, and these changes to make it easier to amend the declaration.
Yes. All big changes.
All really big changes, yeah. And it's important to remember that, these changes were overwhelmingly supported.
Absolutely.
Of the community.
Over 82%.
Yeah. So that really tells you something.
It does. It says that people were ready for a change.
Yeah. They wanted these updates.
They wanted more control.
Yeah. And I think, the big takeaway here is this is really about empowering homeowners.
Absolutely.
Right? Giving them more of a say in how their community is run.
Exactly.
And making sure that, the people who live here are the ones making the decisions.
The ones who are invested, not just investors.
And I think you hit on a really important point there, which is, this is kind of a move away from what some people might see as decades of undemocratic control.
Absolutely.
Right. And moving into a more owner-led chapter in the HOA's history.
That's a great way to put it.
Yeah. So for you, the listener, it's worth taking a moment to think about how these changes might actually affect you personally, right? Think about how a more accessible amendment process could allow for community-driven improvements and how this focus on owner occupancy might change the overall character of our neighborhood.
It's a big shift.
It's a big shift. And staying informed and involved
this
will be more important than ever.
Absolutely.
As we move forward.
Into this new chapter.
Yeah. All right. So thanks for joining us.
My pleasure.
For this deep dive.
As always.
And we'll see you next time.
See you then.